Hey, good afternoon, Juanita.
Hi, Mark. How are you?
Wonderful, wonderful. Welcome, everyone, to Estate and Succession Mastery, brought to you live from
From
Monto,
Monto,
in Queensland. And
which, as I was saying to Mark, is the birthplace of my father. So, lovely Monto. I'm glad that you're visiting.
Well, absolutely. We've had a very successful day up here. They had a session for 12 professional people to come along and basically have a table, and they sent out invitations to all the local graziers and so on, business owners, to come in and have the opportunity to sit with us and ask questions and so on. So it was a great session this afternoon. Met some lovely people, and hope we can help some of them with some of their estate and succession planning, which is what we're focusing on. But today, Juanita, it's your call. It's the captain's call today.
Captain's call.
And you got it.
Well, today we're going to discuss the top 10 mistakes in estate planning. So I often find that it's hard to explain why we believe you should go to an advisor, or not just write your own will, or get some help from professional people, because you often sound like you're just trying to sell yourself. Of course, we want you to go see a lawyer, or an advisor, but the best way to give you the reasons why is to explain to you the mistakes that we have seen happen if you don't, because that's when it goes pear-shaped, and I think you can really see the value and the mistakes that can happen if you just try to fix it yourself.
Let me count the ways, as they say.
Well, number one.
We'll start with 10.
Oh, you don't want me to count down? No, we can't do that.
No. We'll start with 10. So 10 today. We'll see if we can get to the 10.
Okay. Yeah, that's right. If we talk too much. So the first mistake that we see is spelling mistakes and grammatical errors. And so this will often arise when people either try to write their own will or fill in a will kit. I've said before on our live stream that it's better to have a will than not a will, but not so good to have a will with mistakes in it. So the sort of things I'm talking about is when people write themselves explanations about what they want to do, but don't realise that the tiniest little things like and or capitals and not capitals, or spelling of names, can cause problems. So by writing with your best intentions, just those little tiny things can cause an error, which in some cases requires you to go to the court to get fixed. So for the sake of trying to save money by doing a will kit or doing it yourself, that can turn into a $30,000, $50,000 error if you have to trot off to court and get it fixed or get it clarified, because you don't really know what the meaning is afterwards.
Yep. Good point. Good point.
You want to make sure that you listened in all your English lessons at school if you do that. So
well,
please don't. And just to explain that, if we have a will which isn't clear because someone's handwritten it or tried to explain, or there's a spelling error, the way that has to be fixed is to make an application to the court for the judge to interpret it or construct it, and that's why it costs so much. So it's it requires barristers and requires trotting off to the courthouse. So that's why the process is lengthy and very expensive. So do not write it yourself, please.
So for example, if I may stick my head up and ask a question, Juanita, if say you've gone to the lawyers and you've got a will done, and you were going to leave the house in town to John, and the next year you and John have had a falling out in the blue, and so now you're going to leave the house to Sally, and you just go into your will and you cross out John and put in Sally. Not a good idea?
Not a good idea for a couple of reasons. So first of all, any amendments to a will need to be done in a particular way. Or ideally, you just do a new will, but need some initialing, etc. But the thing that popped in my mind when you said that, Mark, if you just say you want to leave something to John, well, which John? What if you know two Johns? What if you meet another John next year? So what does it mean then? So that's a perfect example.
Yeah, I probably should have been more specific with my naming. I would have said John Reginald Smith.
Yeah, I don't know if that would help.
But that's a good point you bring up anyway. So well
done. Yeah. Well done. So the second mistake we've got is not understanding what the role of the executor is. So a lot of people have heard of the term, but quite often when I'm sitting down in front of a client, they don't really understand what that person does and therefore what type of person they should choose or which person is more appropriate. So, a will kit's not going to tell you the kind of qualities that you want in an executor that's named in your will or the jobs that they need to do. So if the wrong person is appointed, it just makes things harder. So, having that advice and understanding the terms that you're being asked to complete in a will kit is really important. You shouldn't just assume, you should, really make sure that the things you're writing correlate to what your knowledge is. So, that's the perfect example. What does executor mean? And other terminology. So what is a bequest? What is residuary? These sort of things that you might need to fill in the blanks in a will kit. If you don't know exactly what the meaning of those words are, you could find yourself in lots of trouble.
Absolutely. And, I'm just sitting here thinking while you're talking, Juanita, I mean, in some ways people would be listening to this and saying, well, that only applies if I've got a, small will, a small estate or something like that. But I mean, these simple mistakes can apply to someone who's worth 100 million, just as it would apply to someone that's worth, 100,000. So, what you're saying, in some ways, someone might say, well, that's a simple thing. I wouldn't make that mistake. But I mean, from your experience, they do make these mistakes, don't they? And
absolutely. Another example of that sort of lack of clarity that just jumped into mind too is when people might write some wording in their will and leave a part of their estate to Mark and then carry on. What is a part? How much is that? So that's another perfect example of where I have seen someone with the best of intentions trying to write their own will, but just by not understanding the nuances of language that they use can cause all sorts of problems. So another good example, similar to the and or sort of scenario.
Okay, very good.
Our next point, number 3, is if you have minor children, not appointing a guardian in your will or not getting the right advice as to what that actually means, what their role is, what happens if a biological parent's still alive. So, one of the most...
May I just cut in here? I mean, this is something I've always pondered on, is one, yes, if you don't nominate a guardian, but point 2 is when it comes to reimbursing the guardian for the work that they're doing, the costs that they're incurring and so on, many times I would think in wills that people would just randomly say, yes, this is who would want to be guardian for our children, and they leave all their estate in testamentary trusts or however they've left it to their children. How does the guardian get paid, and from whose account, and from which area?
Yeah, and that's a really good question because, again, it comes down to the drafting of the will. So it may be that the way that it's, if it's not drafted correctly, it may be that one person's in charge of the money and one person's in charge of the child. And that may be okay in some circumstances, but in many, it's really impractical. So, again, working through those logistical scenarios and asking who do you want in charge of that money. And also, when we're talking about minors, probably very importantly, is what age do you want them to take what their entitlement is? The legal age is 18, but we'll often see 21. We usually recommend 25, sometimes older. And I've seen older than that, which I don't recommend. I think it's a bit harsh. But, these are the sort of things that you need to think through and talk through when you're dealing with minors in a will.
Very good.
Our next one, this is a good one.
Sorry, can I come back?
Sure.
So you've said what the issues are. You might have one person in charge of the money, one person in charge of the child. Whose account does the guardian's costs come out of?
So out of the child's trust fund, essentially. Okay. So if there's money held in trust for a child until they reach a certain age, that money can be accessed by the guardian for the child's maintenance, education, medication, health, welfare, accommodation, that sort of thing. So the guardian won't be out of pocket.
If they run out of money in the estate, then that's just too bad.
Well, essentially, yes. Yes.
Yep. Okay.
So, another reason why it's really important to consider that practical scenario.
Yeah. Okay. Thank you.
Our next mistake is not contemplating marriage in a will, or not understanding what marriage does in a will. So a lot of people don't realise that marriage revokes a will. So to start with, if you have a will and you get married, unless there's specific drafting in the will which says the will is made in contemplation of your marriage, it's revoked. So you might be in marital bliss, you've just had a wedding, you're off on your honeymoon. Unfortunately, you no longer have a will if it's not drafted correctly. So understanding the effect of marriage, and understanding if certainly if you're about to get married, that doesn't mean you should put off doing a will. It means that it has to be specifically drafted to contemplate that you're soon to be married, and you don't want that will to be revoked.
So, Juanita, the more important question here is, if someone gets divorced, does that revoke a will?
No, it doesn't. So in that scenario,
isn't that sort of ironic? Well,
that is exactly right. And in that scenario, that's where we really work closely with our family law team. So well, let's start off with the first step. If you're separated from someone, it doesn't change anything if you're not formally divorced. So, A can separate from B, but they just carry on with their lives and don't get legally divorced or don't have a property settlement. Well, their will and their estate planning documents are still valid. And so if something happened to you, then essentially that person could still benefit from your estate, or have to carry out roles which may just be not what you want at all. So the moral of that story is if you do enter a separation or a divorce, you should really look at updating your estate planning documents. But to specifically answer the question that you just mentioned, if you get divorced, the document itself isn't revoked, but the references to that person are revoked. So if you'd appointed a spouse as executor, or if you'd left a gift to a spouse and then got divorced, as I've said before, it's almost as if you cut their name out of the will, and the document still exists, but it goes to the backup plan. Which probably leads me to the next mistake that we'll often see, is not providing a backup plan. So it's all well and good to appoint an executor or to leave your estate to Bob, but we always recommend that you should have a plan B or a backup, because of the reason being that if that person has predeceased you, or in the case of an executor, for example, if they can't act because they've lost capacity, or if they renounce, they don't want to do it, who's your backup? If you have left your estate to someone and they've predeceased you, you need to put a backup, what the second preference is to where your estate would go. And by doing that, it means you don't have to update your will if something happens to that person, but also more importantly, it means if that person's predeceased you, you're not dying intestate, which is the legal term for without any provision in your will, and then your estate's divvied up according to the law, which might not be what you want. So always consider plan A, and then what the backup preference would be in your will for your executor and your estate.
Yep, good point.
I don't know what we're up to. I think we're up to 5.
Your timing is immaculate.
So the next mistake we see, and this comes down to where you get your value out of your solicitor or your advisor, as opposed to writing something, a handwritten document, or filling in a will kit. So, we've talked in different contexts before about people contesting wills, or if you have an unusual family situation, or you want some advice about what's, as we said before, fair isn't necessarily equal. So if you are concerned about someone contesting your will, you can get appropriate strategies put in place to minimise that risk, or to achieve your wishes in a better way. So the mistake here essentially is not getting the right advice to minimise someone contesting your will if you think that there is that possibility down the track. And, we've talked about that before in depth about what that means and what the processes are. So our regular listeners would have heard about that before. On our next mistake is going back to beneficiaries, and we talked about making sure that they take their inheritance at the right age, and that they have the right guardian and person in control of their money. But another mistake that can be easily made is not getting the right advice on tax consequences of how you leave things in your will. So, for example, if you leave your superannuation to and so the superannuation might not necessarily be in your will, as we've talked about, that's another story. But if you leave your superannuation to a spouse or a minor child, it's not taxed. But if it's left to an adult child, then it is taxed at the top rate. So just that simple thought process about where different assets in your estate should go can make a huge difference to the tax effect. So the mistake here is leaving the wrong assets potentially to the wrong beneficiary, so that the tax result isn't the best one you could. So getting that right advice from your advisors, so whether it's your solicitor or your accountant or your financial planner, etc., to get the best end result for your beneficiaries.
Yeah.
I know you start glazing over when we talk about tax, so we won't talk about that too much.
I wasn't snoring, was I? No, but what I was going to say, Juanita, is that, this is a great example of why the due diligence report that you guys do is such a valuable process, because, I mean, all these sorts of things in regard to who are the beneficiaries, the ownership of policies, is it going to go to the best tax effective source? Do you still have an ex-partner or something on your beneficiary list of your insurance? Have you checked all those sorts of things and so on? I mean, whilst it sounds so simple that, of course we wouldn't do that. I mean, these are the sorts of things that you pick up in your due diligence report, and they're just so valuable to get that information to make sure that the right money goes to the right people at the right time. And it's that simple.
It's absolutely valuable, and it's tangible dollars that will make a huge difference to the bottom line of your estate. So well worth the value in getting that right advice than saving money on a home kit will and getting it wrong. So
yeah, well, look, you keep coming back to the we talk about the cost and so on, the investment. In a lot of ways, this is not a cost. The work that you guys do in regard to your due diligence and getting something professionally done, prepared to a will kit or whatever. I mean, sure, it might cost a few dollars now, it might cost a few $1,000s now, but I mean, at the end of the day, the difference in regard to what happens at the other end, it's not going to be $10,000 difference. It's going to be $100,000, or it's going to be $200,000 difference at the other end if you start getting, or more, if any of these individual things aren't fixed correctly. I mean, all you need is to have superannuation money going to a non-dependent child, and I mean, if that's $500,000, tell me what the tax on $500,000 out of a super fund is to a non-dependent.
Exactly. Yeah, exactly.
So that's just one little tiny mistake that you might have tried to save some money and do it yourself, and yet your estate's going to pay tens of hundreds of thousands of dollars in at the other end.
Exactly. So our next common mistake we see is not having a will correctly signed and witnessed. So there are really specific legal rules as to how a will should be signed and witnessed, and who can witness it. So, for example, you must have your signature witnessed by two people, two witnesses. They have to be in the same place and see you sign your will. They don't need to know what's in it. They have to be over 18. But more importantly, and as my light goes out again,
you need to wave at the ceiling.
More importantly, they must be, as I said, over 18, but they mustn't be named in the will. So you can't have one of your beneficiaries named in the will witnessing the will. So, common mistake for people that might be, whipping something up at home and they've named a family member in the will or the neighbour in the will, and then they get that person to witness them. That can be crucial and render that will not formally executed, which again means an application to the court to get things fixed as an informal will, and that's a $30,000 job. So just little nuances like that.
You could have fun with that, couldn't you? You could pretend to give someone a whole lot of money and say, hey, do you mind witnessing the will?
Well, that would be cruel, wouldn't it? I don't know if that's how you get off.
At least you wouldn't be around to have to worry about it.
Yeah, you used to see a lot having to sign every single page of a will, which is not legally required. You're only legally required to sign it at the bottom or the last bit of the will. But the reason a lot of traditionally that is done, that's every page of the will is signed, is just to have that verification. So, no one can, for example, pull out a page and slip, change some typing and slip it back in. That's of course a bit of a crazy scenario, but it's quite possible. So it's just it's part of verifying the document and making sure that it hasn't been tampered with, because that's another whole topic. If a will has been tampered with or marked, even with a pinhole or a bulldog clip or that sort of thing, then there's issues. If it has to get a grant of probate of the will all done, that all those little things are real, and that's probably another mistake that I hadn't intended on talking about today. But if you have your original will and then you bulldog clip it and there's little marks, then if you have to get a grant of probate at a later stage of that will, the registrar will take issue with those little marks if there's tears in the will or bulldog clips or paper clips. Never paper clip a will, people, because the assumption is that it has been tampered with. Yeah, the assumption it's been tampered with. So it becomes a practical issue where you have to produce affidavits and people have to verify that is the original will. So that's why wills are really treated with such utmost care. So please, no paper clips or bulldog clips.
So, Juanita, I mean, it does beg the obvious question there. I mean, that's fine. I understand that. And yet the kid jumping off the bridge and committing suicide, who picked up his iPhone and recorded his final wishes, and that was declared a valid will. So not suggesting that that's how you do your will, but I mean, the court must get very confusing sometimes in regard to, picking on people putting a paperclip in a will on one hand, and on the other hand, they're saying, okay, well, a recorded note on a phone is valid.
Yeah. So the difference there, and it's a huge difference in that if there is a paper clip or a tear or a bulldog clip mark in a will, the way that is addressed is by a statement, essentially by the person who witnessed the will, verifying that is the original will, or by the solicitor that may have put the bulldog clip in and said that this was the original will. I put a clip on it. I caused that mark. The will hasn't been tampered with. So it can be. Yep. It's a bit of an inconvenience, but it can be relatively simply addressed by filing some statement affidavit material in the court registry and fixed on the papers.
Okay.
The example you gave of a text will, we've seen text wills, video wills, handwritten stuff. If a will hasn't met the formal requirements, which I've spoken about today, such as being drafted correctly, but more so witnessed correctly and signed correctly, there is another avenue in the law where you can apply for that will, that document, to be declared by the court as an informal will. And that involves an application to the court, and a judge must hear all sorts of evidence about that document. And a document in the law can mean a lot of things. It can mean a text message, it can mean a computer file, that sort of thing, a video recording. So the examples that you gave, or some of the stuff that you might see in the paper where some of those crazy things have been declared a will, it's probably taken the 6 to 12 months to get to that stage, and it's probably cost about $40,000 to $50,000 to get to that stage. By the time you get all the evidence together and make the court applications and have barristers involved and go for a court hearing. So it is possible that those things can be found as wills, but it's a long, expensive process. And of course, that money usually all comes out of your estate.
Sure, and I'm sure in a phone recording or something like that, there's no opportunity to create testamentary trusts and all the other forms of protection and so on. So it's never going to be in a complicated will. I mean, it's just going to be a simple
usually
thing,
very simple will. Yeah, that's right. Yeah,
not a lot of money. Yeah. Okay,
All right.
sorry, I interrupted again.
I'm back on track with my numbers. So we're up to 9. So the biggest mistake, another big mistake we see is not dealing with superannuation. So most people are super surprised. I didn't even mean to make that joke. Super surprised.
We
when
could
they come
communicate
in.
about this because we haven't used that word yet.
I know I haven't used the word, haven't we? We've got 5 minutes to go. Super surprised to find out that super isn't left as part of the assets in your will necessarily. So if I do a will and I say I leave everything to Mark, then that doesn't include my superannuation. With superannuation, you need to pop over to your super provider, and there is they will have a special form called a death benefit nomination, which you fill in who you want your super to go to, and that can only go to certain people, or it can then go back to your estate, but you must specifically say that. So a big mistake that people make is thinking that their will deal with their super and they don't have to do anything else, and that's just totally incorrect. And especially these days when we've got so much wealth in our superannuation, it's a really, really important part of estate planning.
Very good, very good. So we have just 3.5 minutes left for number 10. I'm very excited.
Number 10 is not putting in place an enduring power of attorney. So estate planning is not just a will. There are other documents, and I think we've actually done a session on this whole topic another day, but these days it's really important to put in place an enduring power of attorney, because a will deals with things after you die. But what happens if you lose capacity, if you have an accident and you are unable to make your own decisions, or especially with some of our older generation, if they start having mental problems or getting dementia and are unable to handle their own affairs, but still living for quite a long time, in that period from when they've got dementia or lost capacity to when they die, who's handling their affairs? And so there's a real gap there, and that's why it is so important to have an enduring power of attorney. Now, a will doesn't address that whatsoever. So if you have a will and no enduring power of attorney and there's something happens, there's a need, whether you're young or old, accidents can happen, and you want to be able to nominate who the person will be that's handling your affairs in that situation. So super important, not just a will. Make sure you put in place an enduring power of attorney also.
Very good, very wise, and they're 10 very good topics, Juanita. So well done on coming up with all those today.
I feel that we need to throw in our favourite word somewhere.
Well, I was going to talk about communication. If I can just finish off with the importance of communication. So I've been sitting in Monto at a session here today, organised by one of the government departments, and as I said, there was a whole lot of professional advisors there, accountants, lending people and so on, real estate people, whatever, and obviously us from the point of view of succession planning. And I had a number of people come and sit down, chat with me, and it was interesting. In all 3 cases that where we sat down, probably had 3/4 an hour, just free chat with these people. The biggest issue was the communication between the parents and the next generation. In all 3 cases, that was the conflict that had been caused by the lack of communication, the lack of understanding, and certainly where one generation is not talking to the other generation as well. I mean, there's just a whole range of things that people don't know, they don't know, and so on as well. So, at the risk of going through a whole one of these sessions without talking about the issue of communication, today, again, as always, and yesterday when I was in Goondiwindi with clients, exactly the same thing. It just all breaks down to starting the conversation early and knowing who to talk to. And that's why, Juanita, you guys at Murdoch's, I mean, you do such a good job in this area. You're such specialists in the estate and succession planning area. And one of the things that I really admire is that you guys are very good at communicating with clients and asking good questions to get the information out of people, the unknown unknowns, the things they don't even realise they don't know about. So
yeah,
good
thanks,
job
Mark.
to you.
I think if any of those mistakes that we've talked about today, if anyone that's listening thinks, oh, I've made one of those, or I didn't know about that, then make sure that you reach out to one of us so we can point you in the right direction or give you some help.
Yep. Now, this may be a surprise to you, Juanita, but I'm on leave next week, so I think we deserve a week off if that's okay with you.
Oh, okay, no worries.
Unless you'd like to do it by yourself.
Talk to myself for half an hour. No, we'll have a week off and come back refreshed.
Let's have a week off next week. So we'll see everyone in 2 weeks today. Juanita, thanks again. Thanks for organising today, and look forward to catching up with everyone in a couple of weeks. We'll see you then.
Bye now.
See you. Bye. If the music starts, that is.